President Museveni on Thursday appointed Justice Alfonso Munyidolo as the new Chief Justice, becoming the 13th Chief Justice since 1962 when Uganda got its independence. Supreme Court Judge Richard Butera was appointed Deputy Chief Justice, and these two names have since been sent to Parliament for vetting. Now, the Chief Justice is the head of the judiciary, which is one of the three arms of the state, and it is the fourth most powerful office in the country after that of the President, Vice President, and Speaker of Parliament. In Talk of the Nation this evening, we take a look at what awaits the 13th Chief Justice and the Deputy Chief Justice of Uganda in the judiciary. Joining me this evening to have this conversation is Nicholas Opio, who is the human rights lawyer in the country and the Executive Director at Chapter 4 Uganda. Welcome to NTV Weekend Edition.
Well, thank you very much for having me.
Now we'll just get straight into it, Nicholas. What kind of judiciary is the 13th Chief Justice and his deputy finding?
Well, first of all, congratulations to the two of them. I hope that Parliament wastes no time in approving both of them for the positions in which they have been appointed. It is also a very unique appointment in the sense that it is the first time a judge of a lower court has been appointed to head a superior court. Normally, a Chief Justice is appointed from the members of the Supreme Court, but now you have a judge of the Court of Appeal being appointed as Chief Justice, automatically ascending to the bench as a Chief Justice, and joining the peers on the panel who are much senior to him on the bench than he is. But also you have a situation where there's a reversal. A Supreme Court judge is now coming back to the Court of Appeal and heading the Court of Appeal as Deputy Chief Justice. But whatever it is, congratulations to both of them and our best wishes to them. They come to the judiciary at a very difficult time for the judiciary. At a time when there is a lack of confidence in judicial processes, a time when the question of access to justice for many people across this country remains a huge challenge. Access to court itself, but also the processes in court. They come to the judiciary at a time when the judiciary is facing huge backlogs at all stages of the judiciary. But they also inherit a judiciary where the upper bench, the judges and onwards, have had their emoluments enhanced, but the lower bench is still grappling with poor working conditions and remuneration. They come to a judiciary that is now facing allegations of corruption in more vivid ways than we've seen in the past. So it's a challenging time, and I hope the two gentlemen are up to the task. I don't hope, I know they are up to the task because they've been administrators in other places before.
You mentioned things such as lack of confidence in the judiciary by the public. You also mentioned case backlog. So let's start off with case backlog. Now, the former Chief Justice made efforts to combat the huge case backlog, but did not yield much. And as of January, there were about 146,994 pending cases in the judiciary. Now, do you think that there should be a change in how this has been dealt with within the judiciary, and how can we make this, how can the two make it history?
So there are two ways of looking at this. There's the internal problems within the judiciary, but that problem is informed by the external problem. And I think that for a very long time we have not treated the judiciary as a co-equal branch of government. If a seat in Parliament felt vacant, it is filled within 6 months without fail. If a seat fell vacant in the executive, it is filled very, very quickly. But we have ignored the judiciary in terms of human resource. For a long time, you remember the country was without a Chief Justice before Bat was appointed. You have the Supreme Court, the Court of Appeal and Constitutional Court, the High Court still serving under capacity. We just need more judges. We must treat the judiciary as a co-equal branch of government, giving it the resources they need, both financial and human resource, but also giving it the independence that they so deserve. The judiciary is still being administered by a permanent secretary appointed by the executive. We have a judiciary that is still financially dependent on the executive for planning and execution of its financial resources. So the external problem is overbearing. We must begin to take the judiciary as a serious co-equal branch of government with Parliament and the executive, and be able to resource it, to finance it, be able to appoint all the judges they need, all the magistrates they need, if you are to address the question of backlog. Now, if you then address the external problems, you also must look at the internal problems. There are internal challenges to the disposal of cases that also goes beyond the judiciary, because the judiciary is a recipient of cases filed by private individuals, private lawyers, filed by the Attorney General and the Office of the DPP. So regardless of what you do with the judiciary, whether you pay judges all the money they need, if you don't pay prosecutors from the DPP well, or you encourage efficiency in the Office of the Attorney General, cases will still delay in court. And so we have to look at the entire ecosystem of the judiciary and be able to make meaningful, wholesome reforms if we are to address the case backlog issue.
Okay, now when we getting away from the case backlog and taking a look at corruption within the judiciary, it has been something that also the former Chief Justice really did try to say, you know what, we need to get the public's confidence back. How far do you think that this has come, and how can these two now be able to gain the public's confidence?
I haven't spoken to the retired Chief Justice about this, but I reckon one of his deepest frustration and regrets is that he came into the judiciary promising to address the question of corruption. And he did some things, especially at the lower bench, suspending magistrates, referring them for judicial service commission processes. But I think that by and large, in the upper bench, he felt helpless. I know a set of lawyers who presented to him a detailed report on allegations of corruption against judges and other judicial officers. That report ended nowhere. So I think the deepest frustration has been the inability to root out corruption from the judiciary. If the new leadership of the judiciary is intent on rooting out corruption in the judiciary, they have to develop a close relationship with the Judicial Service Commission, the body responsible for disciplining judges and judicial officers, so that the Judicial Service Commission is fully functional. It is dedicated to addressing these concerns of corruption, because the Chief Justice cannot dismiss a judge. The Deputy Chief Justice cannot dismiss a judge. The judge is only dismissed through a process headed by the Service Commission. And so they have to be willing to investigate cases quickly and refer them to the Service Commission for appropriate action. But they also have to look at internal processes. The judiciary has an integrity committee. There are judges we know as day follows night, that it's public secret they have been involved in issues of corruption. Let's start with the two whose names have come up in a US sanction. The one who has retired should be subjected to criminal investigation and prosecution. The one who is on the bench must immediately be put on leave and subjected to investigations and a fair hearing by Service Commission. That will send a strong message of their commitment to dealing with issues of corruption in the judiciary. Okay,
now lastly, as we wrap this up, as a country we're heading into the 2021 general elections, and what role do you think that these two, the Chief Justice and the Deputy Chief Justice, will have to play during this time and even after the election?
So pre-election dispute resolutions have been decentralized to the Electoral Commission by the amendment in the law that we had the last time. And so in terms of judicial role, it's very minimal pre-election. But post-election, you have serious issues to deal with. The question of parliamentary electoral petitions, for example. To make a member of parliament whose election has been challenged serve in parliament until the 4th year, and you hear the challenge against him, is really a mockery of the process. I hope and pray that we can expedite processes of electoral justice, both at the High Court, but also at the Appellate Court. But we also must address the concerns raised in presidential election petitions at the Supreme Court. The last election petition came up with recommendations for reforms, both for the executive but also for the judiciary, that we must begin to address the concerns that have arisen from these petitions in ways that will restore public confidence in the courts. I think that it is possible. It requires the will and the political support for them to be able to do what they have to do.
Okay. Now, the last part of this is also taking a look at how security forces come into play when it comes to the judiciary, and maybe say how we've seen suspects being arrested after they've just been released. And how do we hope to now, perhaps moving forward in this new wave of leadership, to say that the judiciary is independent and whatever they say stands?
In 2005, when the Black Mamba raided the High Court and rearrested suspects who had been granted bail by a judge of the High Court, the entire Uganda Law Society mobilized and staged a vigil at the High Court in their dark, black, ugly gowns. The principal judge at the time, the Justice, retired Justice Ogola, wasted no time in his repudiation of the actions of the court, both in terms of public statements, but also in terms of representations to other organs of the state. We want to see bravery, such bravery return to the courts, so that the courts can take their place and be able to repudiate in very strong words actions that undermine judicial independence, including the rearrest of suspects in court. But secondly, the courts have no business acquiescing in cases of human rights violations. It has to be a principle that all cases where human rights violations have been proven or is manifest, the court should reject and refuse to hear those cases. It would send a strong message to those actors that their actions are actions in futility, and that the court cannot accept and acquiesce and be a party to human rights violations. Too many times you have people taken to courts charged by the DPP, and they are proud to tell the court that investigations are underway. Meanwhile, the person is being remanded in detention. They have charged them for offenses they have no idea what it is yet about. The courts must reject those kind of arguments and protect individual liberties and human rights for it to be able to gain the confidence of the public. Okay, well, thank you so much for joining us on Talk of the Nation this evening, Mr. Nicholas Opio. He is the human rights lawyer within the country and executive director at Chapter 4 Uganda. The conversation was a look at the new wave of leadership within the judiciary. We're now going to take a short break, but we'll be coming right back.